serious mentorship of my colleagues that if fortunate enough to be taken in as a judge, I'll leave behind, I have absolutely no doubt that they will still be able to discharge their mandate.
All right. Again, listening to what you've told us, it is so clear that your specialty has been in the area of criminal prosecution. And when you become a judge, there is a possibility that you could even be attached to the commercial division, for instance. How would that be now, given the fact that your life, yes, nearly all your public life, you've been a public prosecutor dealing with criminal matters?
Thank you, my lady. Let me correct one thing. When I joined as a prosecutor, largely, I was posted first station to Meru Station, where at the time, when I was in the office of the Attorney General as a State Counsel too, we were handling both criminal and civil matters. Later, of course, after the office of the DPP was delinked from the Attorney General, I moved on to prosecutions, but within prosecutions, I currently head the Judicial Review and Constitutional Petitions Division, which I have done for the last 6 years now, so that I have a good grounding on matters judicial review and constitutional litigation, besides what I have been doing in criminal law practice.
Fair enough. And finally, from myself, you do indicate in your letter of application that you possess personal attributes for this position of judgeship. What are these personal attributes that you think you possess that are ideal or make you the ideal candidate for the position of a judge?
Thank you, my lady. First, I would say, as a person, I am a very good listener. That helps me when making decisions about anything, that I take the advantage of listening to everyone that comes before me before I make a decision on whatever issue that I'm looking at. Secondly, as a public officer, over the last 23 years, I have learned on the job certain things that public officers must never do. Number one, on issues of integrity, I have no doubt I am a person of integrity. Reason being, if you're a public official, you are unlikely to survive that long if you are not a man of integrity. Why do I say so? You'll be required to do things, both in private and in public, that persons who lack integrity would not escape public notice.
Thank you. That's all from me.
Thank you, my lady.
All right, just a few questions.
Yes,
now, I'll not test your legal mind. I have no doubt you have a very good legal mind.
Thank you.
I want us to discuss a different issue.
Yes.
Now, the administration of justice ecosystem.
Yes.
What do you think is the biggest challenge, or at least if not one, at least two challenges that you think are facing the institutions, the governance issue institutions that relate to the administration of justice?
Thank you, Commissioner. First, I would identify the question of stakeholder collaboration and cooperation. For a very long time, public institutions in this country involved in the in the justice system have been operating on what I would call a silo mentality approach to issues. So that when the judiciary is under-resourced, it is not the business of the Attorney General to speak about it, or it is not even the business of the DPP to speak about it. We must, as a country, agree for us to be able to deliver to the people of Kenya. We must change our approach to some of these things. Secondly, the resourcing of our institutions that are charged with the administration of justice. Take a population of 50 million Kenyans, and the statute as it stands today contemplates a situation where you have 200 judges in the High Court, for example. Given full and optimal capacity, you will have to match those numbers with 50 million, and given the case rate that we have in this country and the litigious nature of Kenyans since the promulgation of Constitution 2010, you still realize we are far from it. And The public needs to be served more expeditiously, efficiently, but we cannot do so without resourcing the institutions so that they increase their, the human capital as well as institutional infrastructure.
I want us to address the fear of the public.
Yes.
When they look at the governance institutions,
Yes.
the commissions, the judiciary, the ODPP, you know, all those institutions. What would you consider to be the biggest fear today that the public has, or the perception they have vis-a-vis the institutions that I've made reference to?
Well, I would say this, out there, the public that we are serving seems to have a very low confidence level in terms of our ability to deliver on our mandate. But I would not blame it on anything other than the lack of information on their part. Reason, having practiced law in these courts, I have seen judges, and His Lordship Judge Ibrahim, before whom I appeared for the longest in Mombasa, a judge sitting in court from 9 to 5, and you expect them to deliver judgment in time, handling not less than 10, 15 to 20 matters. That is impossible. So that the public also needs to be sensitized and informed. And I like some of the things that I've come across when looking at the vision of the Chief Justice on how we need to approach justice. That we need to sensitize the public and make them aware what are the challenges, what are the opportunities that lie within the justice sector that we can leverage on. Yes.
But if you know, and I'll not take too much time.
Yes, please.
Now, what is it that you think then that needs to be done, and what would you do as a judge to increase the confidence level? Because, you know, we would be lying to ourselves to say that the confidence levels are not dipping generally when it comes to institutions that are meant to ensure that administration of justice is one that people have confidence in, you know, unless, of course, we want to, you know, we are not living in this country.
Thank you, Commissioner. Given an opportunity to serve as a judge in the station that I would find myself in, I would do two things. Number one, utilize the CUC that exists in the court stations to come to some consensus with all the stakeholders what needs to be done to do this job differently. What is it that is the challenge that we have to contend with in terms of progressing our matters? Why is it that cases take so long? By doing so, from the CUC you would be able to tell, for example, is there a need for us to change the way we do cases? Are we going to adopt virtual court hearings? Are we going to move away from oral testimony to hearing of cases by way of affidavits, so that we are able to approach this matter in a holistic way and at the end of the day win the confidence of the people? There is yet another window. I have noted of late the judiciary has gone out, something that never used to be to happen before. The judiciary was known to be an institution that everybody dreaded, but at least now there is interaction, public interaction, so that the stakeholder needs to
And for you as a judge, what do you think is the role of the judiciary in ensuring that at the end of the day, that the public can look at whatever is being done within that ecosystem and they can have confidence that there will be justice, whether for the victim or for the public or for the accused? It really doesn't matter in terms of confidence.
Thank you, Commissioner. Let me begin with the issue of bail that is being granted, or terms that we ask for in matters of persons arrested during riots or public demonstrations. And I would say this, for purposes of information, Commissioner, I had the privilege to argue the first bail application after Constitution 2010 before Honorable Justice Ibrahim, the case of Mugunya, Danson Mugunya. And in that decision, there is a checklist that the judge has ably laid out in that decision that one needs to look at. So that for me as a prosecutor, and even as a judge, if I were to be one, I would be able to find able guidance within the precedents that exist in this country on the issue of bail. It matters not what a public prosecutor will tell the court, as long as the law says you can give bail, then nothing stops the court from doing so. And no one should begrudge a court for simply giving bail, which in any event is a constitutional right. And what I would say is this: courts should stamp their authority. When we make applications, we are not a special litigant. We are a litigant like any other, only that then we come under the color of public interest at times. And then you weigh what are the consequences of some of the actions that these people are involved in. What are the reasons that you lay out? And most importantly, in the applications for bail, there is a requirement that you file affidavits. What are the reasons that these prosecutors are presenting before these courts? So that, for me, I would say it is up to the judge or magistrate before whom we appear to dictate the terms, because that is what the law requires of them, and nobody should take offense of that. Now, the right to picket under the Constitution is a guarantee, and that we cannot take away from the people. So that if they engage in demonstrations and they are arrested for any infractions that they may find themselves involved in, then there is every reason, of course, for them to be charged, because again, a demonstration or participation in picketing does not mean an open check to commit all manner of offenses. We have had instances where people are attacked by persons purporting to be on some of these demonstrations. Then I turn to the question of withdrawals at advanced stages. There is a myth, let me call it so, that has gained some kind of public acceptance, that the DPP is withdrawing matters left, right, center. That I would wish to debunk by saying this. If you read section 87A of the CPC, for instance, a withdrawal can occur at any time, even before judgment. That statute is dry in the sense that it doesn't tell you what are the reasons that the DPP must give before such a withdrawal happens. Therefore, then it takes you to the question, when an application is made for withdrawal of a matter, the most important and critical thing that Article 157 requires of the prosecutor to give are reasons. Are these reasons that are being advanced reasonable enough for a court to reach a decision to allow or to disallow a withdrawal? Why do I say so? The constitutional architecture creating the office of the DPP allows him to withdraw matters, and there are very many reasons that can lead to a withdrawal, and I will list just a few if you allow me. Number one, you get a very good case to court, witnesses are compromised. That does not happen when you are in the know. Witnesses are threatened at times. That does not happen within your knowledge. But when you call them to come and give evidence, witnesses start giving you excuses left, right, and center. Oh, I cannot be released from my place of work. Oh, I have a sick child, and all that. You get to a point, some will tell you expressly, and these are matters that you cannot, of course, come to court and start saying everybody has run away from my case. If you have no evidence to offer, you will say I have no evidence to offer. But there are certain things that always will inform a decision to withdraw a matter. People may think it is abuse of power, but then what is the function of the court in terms of supervisory jurisdiction to supervise the DPP? When you have good reasons to challenge that decision, nothing stops anybody from applying to the High Court under judicial review. You can seek whatever order you want, mandamus to compel the DPP to prosecute. If you are successful, that happens. There is also the option of private prosecution. If one believes DPP is withdrawing a matter simply to assist a particular accused person, then there is that option of private prosecution. But I can tell you, for the few that I have personally presented applications to withdraw, we have had valid reasons to make such applications. Reason, you have a matter, you have reached at witness number 22, and the rest of the witnesses are reluctant. What do? And you have not proved anything. You look at the file, there is good evidence, but nobody is telling you why these witnesses are not even ready to come and give evidence. Those are realities we have to confront.
Just taking it further from that question about public confidence,
yes, my lady,
in the judiciary, I just want you to tell us why, although the independence of the judiciary is underpinned in the Constitution, we still have challenges about the independence of the judiciary. Why is the independence of the judiciary a challenge?
Thank you, my lady. I would say this. Part of the reason why the independence of the judiciary is under threat, so to speak, is because, one, we come from a situation where politics of this country never distinguished between institutions and political parties. That is the reality, and that was actually part of the reason why we ended up with the Constitution 2010.
So they consider judiciary as another political party?
Precisely, sometimes an extension of it. In fact, the historical fact is that the judiciary, as introduced by the white man in this country, was supposed to be a tool for oppression to the blacks. And therefore, continuing or going forward after independence, we continued seeing things being done left, right, and center that actually validated that argument. So that we have gotten to a point in 2010 and we say as Kenyans, wait a minute, we must change the way of doing things. People will take time to appreciate the new constitutional dispensation.
Thank you. So what should we do to remedy that situation?
My lady, I would highly advocate, now that we have a forum, the NCAJ, which brings everybody on board, the executive and all the players in it, we need to keep saying, and repeatedly so, that these courts must be respected. Courts have a role. It is the last card that one has to their safety and liberty. If we destroy our courts, then we are all at risk. But then, for us to make a case, we have to begin by getting a stakeholder buy-in from the institutions that we work with, as the judiciary and prosecutions, as well as investigators.
Yeah, thank you. Now,
thank you, my lady.
You know, we are looking for somebody who is judge ready, and I have no doubt in my mind that you have experience appearing in these courts for the last 23 years. If you were successful and you landed in a court, how would you organize it to make it efficient and, of course, accountable to the people? Just give me a few things you would do to make your station work.
Thank you, my lady. I think the first thing I would do the moment I report to that station would be to undertake what I would call a case audit. Find out what kind of cases do we have in terms of numbers, complexity, and all that, so that I get informed about the status of the judiciary in that small space, the station that I'm serving. That is number one. Why would that be important? It would be helpful to me to establish, given the staff complement that we have in that station, are we able to deliver? Or is there a case that we can make to the administration of the judiciary for additional hands and minds to deal with these cases? That, without undertaking such an exercise, then one would be operating on an assumption that things will work, which doesn't normally work. The other thing would be changing the style in which we handle our cases. If, for example, I find a situation where a court purely proceeds with matters in the traditional way of doing things, that is the old style where witnesses have to travel thousands and thousands of kilometers to come to court, when you can utilize teleconferencing and such other facilities. If that's stationary, then I would employ such techniques to deal with them. Cases.
You would also consider the other alternative methods of accessing justice?
I agree, my lady. In fact, the alternative justice method, I have tried it very recently in one of the cases, the Solai Dam tragedy. I had the privilege of handling that case, and we delivered justice through that system, the alternative justice system. And I think going forward, if the judiciary adopts that style of justice delivery, we are going actually to win public confidence sooner than we expect.
Okay. So in that court, you will find also there are cases filed, to seek enforcement of rights. Let's talk about economic and social rights that are enshrined under Article 43 of the Constitution. Just tell the Commission what types of rights are these ones envisaged under Article 43.
Article 43, first, the right to health, to good health system that everybody enjoys. The right to health system, the good environment, the clean environment, so to speak, so that when...
I think environment is a standalone.
Yes, thank you, my lady, for correcting me on that. Yeah. The other right that would immediately come to my mind would be, it's escaping my mind, I'm sorry, the right to health, basic education. I think that's also one of the social rights that people are entitled to. Sorry, it's just evaporated.
Refresh on that.
Yes.
Justice Majanja.
Yes. Thank you, Chief Justice. I want to follow up on what you were talked about, ADR and the Salai case. That was initially a criminal case.
Yes, my lord.
So, for whom did you get justice? When you look at it in your own perception.
My lord, I would say this: justice to both parties, the victims as well as the accused persons. Because as a prosecutor, when I take a case to court, it should never be the business of a good prosecutor just to mount prosecutions with the sole aim of securing a conviction. You must also have the concept of justice that looks at the accused person as well as the victim. Why in this case I say justice was served to both parties is this: the victims had waited for so long to the looking forward to the conclusion of the matter. That was not forthcoming. Number two, even if we ended up with a conviction, for instance, that would not immediately have translated to any reparations on their part. So that for them, they would still be forced to revert back to the civil process to seek compensation from the accused persons, if that were to be the case.
Because the major criticism I see is that you see, and I'm not making any judgment.
Yes, my lord.
You see, criminal law is meant to punish people.
Yes.
And there is value in punishing people, isn't it?
Yes, my lord.
That people should not get away because they, for example, can pay their way out.
Yes.
Or rely on an effective process to say, okay, because you may wait for so long, we'll offer you money and we get off. So don't you see that as a problem? Because people want the general public wants to see people punished for the wrongs they do?
My Lord, that concern is valid, but the persons who hold that view forget one thing. In every trial, there are two possible outcomes. One of them could be an acquittal, where the victim walks away with nothing at the end of the day. So that even as we pursue criminal prosecution, you must also be alive to the fact that at the end of the day, a judgment will come. That judgment may not necessarily be in your favor. So that it's a question of delicate balancing of rights. What is it that serves the victim best in the circumstances? And I would say a case like the one that I've just given, strict liability, its enforcement in a criminal law setting. There could be every available opportunity to an accused person to raise a defense and sustain it of, say, for example, an act of God. What
Okay.
happens?
I'm satisfied with your answer, but I'm
Thank you,
just
my
still
Lord.
concerned
Thank you, my Lord.
that people can actually get away with offenses. But one of the problems you say that the case took so long. Why did the case take so long? And what would you do differently if you are now in a position of the judge to make sure that that doesn't happen? Because you see, that's the way people game the system.
Yes.
They say, okay, you will take so long, so we'll pay you now so that we avoid the ultimate penalty.
Yes, two things. Number one, the number of victims involved. We had a whole 49 families that had lost relatives. So even alone, production of identification of the post-mortem forms in respect of each deceased, you have a whole 49 witnesses to line up. So that speaks to the number of witnesses involved in the entire trial. Secondly, the distance also involved. You have a situation where the incident happened in Nakuru. These people have to cover kilometers and kilometers to get to Naivasha. By the time they arrive in court and say, for example, you have a single day hearing, you're only able to take about 2 or 3 of them and the day is over. What I would do differently is this. The courts need to devise strategies where you have a matter that involves many witnesses, a relocation of a court to approximate point where all witnesses, or at least a big number of them, can be heard at once or within a very short span. That happens. That would greatly help and reduce the time taken in processing these cases.
Okay. Thank you.
Thank you, my Lord.
No further questions.
Yes, my Lord.
Mr. Muteti, I know of your work. I've worked with you all over in Mombasa, Nairobi, and elsewhere. I know the quality of your work. I've also read your sample writings, and I think you have done a good job. And really, you have achieved so much in that area of prosecutions. There's no doubt about that. Now, here you are applying to be a High Court judge, where you will not be confined to criminal matters, where you are specialists in constitutional matters, the penal code, and generally matters of criminal law. But here now you deal with any kind of matters, including commercial, including equity, including land, and succession and so on. So that means that you'll have to do a lot of quality research and relevant to those subjects. How do you intend, if you appoint a judge, how do you intend to, in a very short time, get the skills of writing judgments in those areas that you basically have not practiced for 23 years?
Thank you, my Lord. My Lord, I think learning is a continuous process. And I come from a background where I have stated the area that I've actually been covering. But I would say with confidence, if I found myself in a division that I have not interacted with the matters that are found in that division, I would quickly embark on familiarizing myself with the latest developments in law about that particular area of practice. How do I do that? At least we have now online reporting of cases where a judge can virtually research from anywhere in this country or even in the world. And you are able, if you are industrious enough as a judge, to access material that would assist you answer any question of law. Unlike in the past where we were restricted in terms of law reporting and all that. And also benefit from my peers in the judiciary who have been there before me.
Yeah, I've seen your writings, including your thesis in your master's degree, and also in some of your judgments, including the sample writing number 3, which involved DPP versus the case of Olo and Pius Ngugi.
Yes.
Do you recall that?
Yes, I do recall, my lord.
Yes. So I've seen the way you have arranged the way you have arranged the structure of that submissions in that very important matter. What are your thoughts about legal writing in terms of judgments?
My lord, sitting down to do a judgment, the structure, in my view, would be that first, I bring out broadly what the matter before me is about as an introductory part of my judgment. Go down to the issues that I distill from the pleadings or that parties filed before me. Identifying those issues, then I go to evidence analysis to see whether the evidence presented answers to all the concerns raised in those issues. Thereafter, undertake an analysis of the law vis-a-vis the evidence. And with that, I draw my conclusion and the orders that I would be able to give.
Have you read the judgments and works of Lord Denning?
Well, yes, my lord, but I wouldn't say the full text of the judgments, mostly
But what
in the law.
about his style of writing?
I would say it's admirable, but then again, complexity in the manner in which you deliver yourself has its own dangers. That as a judge, you are expected to communicate in the what I would call the simplest and easiest way of parties that come before you understanding you, so that the consumers of your product are able to associate with your reasoning without difficulty.
Okay. What do you think of the decision by the writing of Justice Madan, Chief Justice, as he then was in the case of Githunguri?
Well, I find that decision a very interesting one. Justice Madan had his way with words, and quite frankly, one of the things I would say that comes out of that decision is a judge pronouncing himself on a reality or a constitutional moment that they find themselves in, like was the case in the Githunguri matter, where he had to pronounce to the litigant the importance of there being a constitutional order that would grant him the safety that he found himself in. Very admirable indeed.
Thank you. I wish you all the best.
Thank you, my lord.
Thank you.
Thank you, Chair. Good afternoon once again,
Good
Alexander.
afternoon, Commissioner.
And maybe you, in a different stage, you'll tell us why you're called Alexander the Great. I have a few questions for you.
Yes, Commissioner.
What would your approach be in deciding cases within the context of the philosophy you intend to bring to the judiciary?
In my approach, I tend to lean towards on legal realism. Deliver justice that responds to the realities of the moment in terms of the dispute before you. What is it that the law says should happen in the circumstance you find yourself? Now, applying that law contextually, does it answer the question before you? If not, is there a case of you now infusing new thinking that could inform legislative change through your judgment, so that we do not apply the law in almost what I would call a vacuum kind of approach, where you are insensitive to all the happenings around the court. Basically, what is it that the purpose, the law that was set out, what did it seek to cure, for example? In the present circumstances, does it answer to that, or is there a defect that needs to be remediated?
Thank you. And when you say it has to respond to the context, would the political question then be among the things you will need to look into?
I would say politics is one thing a judge must stay away from. So that if the political convenience of the moment dictates that which the law does not allow, as a judge you must be firm and say no to it. So that you must make an independent decision on the basis of the law and an objective assessment of the matter, as it were, but not political persuasion.
And just listening to your response from the questions the Vice Chair and Judge Majanja raised,
yes,
with regards to the Solai case,
yes,
and the various instances where the DPP would then withdraw charges. It is said that the poor man looks upon the law as an enemy, not as a friend. For him, the law is always taking something away from him. In another saying by a professor in the US, Professor Lawrence, on the whole, it is reasonable to suppose that justice is not as blind and classless as it pretends. It squints to one direction. My question with regards to those questions that the two commissioners had raised, how come we never hear of the very petty cases receiving this type of treatment, the withdrawals, the negotiations? We have had instances where people are saying that the justice system in the country is not pro-poor. Would you agree with that statement?
I would not agree with that statement for the following reason. Countrywide, matters are withdrawn almost on a daily basis in different courts for various reasons. The only thing that I think leads to public condemnation mostly of the DPP's action of attempting or even withdrawing matters, ask yourself what kind of matters. There are matters that are highly reported on, but I can tell you without any fear of contradiction as I sit here, withdrawals are happening countrywide. But then the reporting is only concentrated in certain few areas. You will find if something happens in Mombasa today, we will all see it at 3. Nairobi, same thing. Kisumu, same thing. The main towns. But if you went to, say, the court in Githunguri today, certainly, I'm sure, you would find 1 or 2 withdrawals happening, but nobody speaks about it. So that the poor in society are not necessarily discriminated upon whenever we of late. The ODPP has started actively reporting on almost everything that happens in that office through our communications team. Something that never used to happen.
Majorly, they are usually convictions.
And many other things. Yes. Sometimes even those convictions, sometimes they are only reported because, again, you will also notice from the media. Mm-hmm. Sometimes when we do good things, nobody bothers to report them. But they only pick the negatives because they say that is news. When you secure a conviction, it doesn't matter whether you have secured a conviction of 100 years against one man. For them, that's not news. So that for us, we have to actively report on what we are doing. I've also seen that the judiciary, through its communication, has also become very forceful in terms of reporting on what is happening in the courts. whenever issues arise. And I think that's a positive development that needs to be encouraged. We must be able to speak about what we are doing as institutions.
Okay. Still on the issue of pro-poor,
Yes.
you will notice that in most prisons, again, you have petty offenders, majority, who are serving term.
Yes, Commissioner.
You go to remand, you find it people from informal settlement. You go to big cities where you have the so-called kanjo, arresting Mama Mboga, Baba Baiskeli, and when they ask for reasonable bail terms, you oppose. And I know of a case where a woman was arrested for failing to adhere to the quote-unquote kanjo laws. And she was then given a bond of a cash bail of 10,000 shillings. She was unable to pay that, but after 1 week, she was able to then get friends to pay for her. When she got home, her child had been defiled, and 2 other children had left their home because they didn't know where their mother had gone to. They were residing in informal settlement. Does the judiciary or the DPP understand how their work and how them not being in touch with the community affects service delivery, or tries to demystify what their role is in the community?
Thank you, Commissioner. I think presently, as an office, speaking from the position that I sit today, we have a new, what I call strategic direction provided by the new DPP on people-centered prosecutions. We are applying alternatives in terms of diversion in those small cases that you're talking about, where somebody is arrested for hawking in the streets. Honestly, I would not even understand why a prosecutor, worth his name, would rise to oppose the release of such a person on bail. Number 2, the reasonability of the bail terms that we impose as courts also needs to be reflected upon. We have a bail, guideline that was issued by the Judiciary. Are we following it? And I believe largely some of these things are happening because people don't pay attention to some of these small things. Otherwise, I wouldn't understand why a lady who was simply hawking to look for bread for the children would have to spend in custody of a such when we can apply community service orders. All these things are available to the judicial officers.
My last question is around the conflicting decisions from superior courts.
Yes.
With regards to several issues of within the criminal justice sector. And I would speak to issues such as mandatory sentence, issues around sexual offenses, what does life sentence mean? Some of these matters are live in court, but I just want you to give us your feeling with regards to the effect of these contradicting decisions when it comes to administration of justice.
Thank you.
And what you will do to ensure that that does not happen.
Thank you, Commissioner. I think when we have contradictory decisions of the courts, personally as an advocate or as a prosecutor, if I encountered such, the first thing that would come to my mind is this. In the case where I get a decision that I find conflicting with an earlier precedent, it is my duty to escalate that matter to an higher court, so that you settle the law on that matter on the basis of a judicial pronouncement from a higher court. It doesn't serve any purpose for practitioners to sit with judgments only to apply them when occasion suits them. For instance, you find one person wants to use a decision today because it suits the interests of their client at that time. Tomorrow they are trying to apply the same decision, the different decision to at least again serve a different client. So it is actually a duty to all the advocates in this country, where you encounter conflicting judicial decisions, escalate the matters up to even the Supreme Court and get guidance on some of these issues.
Responded to the, is it a concern
It
in
is.
the access
It
to
is.
justice sector?
It is.
Why is it a concern?
It is a concern because two things are likely to happen. Sometimes when you have conflicting decisions, and I have to say this without any fear of contradiction, the avenue of corruption is open. Depending on who wants to deliver what kind of a decision for what reason, for whatever reason, one could very easily hide behind a contradictory decision, even when they know it's plainly wrong.
That is all the best. Thank you.
Thank you, Honorable Chair, and welcome again, Honorable Muteti.
Thank you.
Now, we engaged the stakeholders when we were preparing for this exercise, and they told us that they would want to see a judge who understands the complexities of the judicial system, including the challenging environment and the power dynamics.
Yes.
Do you agree with that statement? And why, if yes, why do you think it is important?
I do agree to begin with, and it is important to get persons who are adequately informed of the current status of the judiciary and what are the concerns around the dispensation of justice, so that even when they sit in judgment, they remedy the situation that is obtaining at the moment. If you get a person who is a stranger to the cause, so to speak, they are unlikely to appreciate what, for example, a magistrate sitting in Kithimani today, grappling with a matter where they have conflicting judicial decisions, they are not able to find guidance. But then that judicial officer, because they had no advantage of practice, so to speak, they may not even be aware of some of these decisions. So for me, I would associate with the concern by the stakeholders, get people who are informed about the circumstances that we find ourselves in as an institution, that is the judiciary, and as a country as a whole.
Just following on the question that you were asked earlier on the independence of the judiciary and the interdependence of the three arms of government, would you just briefly unpack for us the meaning of that statement?
Thank you. I must mention that there cannot be a situation where institutions of government are not operating in an interdependent manner. Why? Because by the very architecture of government, we are all arms of government, and that government is one. There are not two governments. The question of independence of the judiciary becomes important when you look at institutional independence and decisional independence, so that one has to address the two. When the judiciary, say for instance, consorts with the executive on any matter, or even with parliament on any matter, it should never be the song in town that the judiciary has been captured. We live in this country and we've had these things. The fact is, you get a budget from parliament. How then, if the chief registrar does not engage the committee on budget, argue their case? They must be independent in that respect. But then, as regards actual decisions in cases, then that is where the independence of the judiciary, people need to draw a line. That a judge will decide a matter based on the law and the evidence before them, but they will not be forced to look over their shoulders.
Thank you very much. Back to you, Chair.
Thank you.
Thank you, Chair. I like that answer you've just given about independence and interdependence. And I also liked the answer you gave when the Chief Justice or the Chair was engaging you earlier concerning how you'd hit the ground if you're successful to be appointed as a judge. And you mentioned that the first thing you want to do is to conduct a case audit and then determine the complexities of the cases, or the types of cases, and then also see if there are other innovative ways of dealing with them other than the traditional. I think that is even the reason why we also invite and welcome the idea of having people from outside coming into the institution. So now I want to give you a practical situation just to see how
innovative you can be
Thank you,
in
Commissioner.
dealing with some of the cases that you will encounter if you become a judge. So imagine a situation where you have been posted to the family division.
Yes.
So you get there, they have a caseload of about 15,000 cases. Currently, I think being handled by around 4 judges, so you make the 5th judge. And you find that majority of their cases are succession cases, and they are pending hearing of objections and protests. So if you could just, you've done your case audit, you found there are 15,000 cases, 70% of those cases are succession cases pending hearing of objections and protests. Could you share with us some innovative ways you will deal with them to ensure they are concluded before 3 years?
Thank you, Commissioner. Firstly, I would look at the cases applying the first test. Number one, are these litigants represented? That would be the first aspect that I would use to determine what cases to place when. So that if I have a situation where I have matters that are unrepresented, that tells you as a judge that is a difficult day for you. Because the manner in which litigants prosecute their matters is completely different from the approach that advocates take. So that for represented cases, if you list them, advocates will appear before you and you will be very quick in deciding, are we going to do this through viva voce evidence or affidavit evidence? That would help you in knowing how many cases you can possibly conclude through that method. Which of these cases must go for hearing and what are the good reasons for each one of them? Now, in the unrepresented cases, sometimes litigants will be before court, not because they have such a big grievance, but if you send them, for example, to the court annexed mediation, if it's a matter that can be mediated upon, again, you divert so many cases through that mechanism, so that these cases, once the mediation registrar has listed them, and you send them for mediation, you would be able to conclude quite a number. And I think that is a means through which one can very easily resolve quite a good number of cases.
Okay, I'll take that, although you'll be surprised to find out if you're successful that it is with the represented that you'll have, the unrepresented that you'll have less problems. But that's that. The next question I want to ask you concerns demonstration of performance.
Yes.
From your end. You were told earlier that before we embarked on this exercise, we engaged stakeholders to get their feedback on the kind of judges they want.
Yes.
And one feature that, one attribute that featured prominently was that they wanted hard workers. They likened it to a tractor, in fact.
Yes.
They want tractors, people who will come in, hear cases, and close them. So could you demonstrate to us that you are a tractor, so to speak?
Thank you. Thank you, Honorable Commissioner. Indeed, I am one. And I will use 2 of the stations that I have served before as an example. In Meru, when I was posted in Meru in the year 2002, where I had the privilege to appear before Honorable Justice Lenaola and Honorable Justice William Ouko, we found a very serious backlog in terms of criminal cases. People staying in custody up to 7 years before trial. But then we undertook the case audit that I talked about, listed all matters in terms of age, and we prioritized all the old cases. Madam Commissioner, you'll be surprised. We would start court at 8:15 and leave that court sometimes after 6. A single prosecutor serving a judge Monday to Friday. That I would be able to do. The other court experience that I have had of serious work where a prosecutor, if you are not up to that kind of strength and measure, you would not survive, is the Mombasa court. Another very busy station. I survived. In Meru I did 7 years, in Mombasa I did 8 years. Through the experience that I gathered in those 2 stations, I think I am that candidate that those stakeholders are looking for. I do not shy away from work.
Okay, thank you, and I wish you well. Thank you, my lady.
Commissioner.
Thank you very much. You've answered quite a bit on the other issues. I'm aware you are now in the prosecution section,
Yes.
but you are very close cousins with the other state councils.
Yes.
You also worked in the AG's office some other time. I'm asking you, what can you tell us about the situation where the state councils fail to represent Kenya in the case of the Somalia, yet our military sometimes is expected to put their own lives on the line, but your cousins in the AG's office fail to actually appear in court?
Well, Commissioner, first I would wish to highlight the fact that I am not fully conversant with the facts leading to their absence, but I would say this of the absence. Where council has a matter that has been minuted to them, it is the duty of that council to ensure that brief is attended to, and there cannot be excuses about it. So that if then they did not attend to the matter and you are required to do so, then that is a case that calls for questioning what exactly led to that. Was it a case of dereliction of duty or pure assumption that all was well, only for Kenya to end up losing in the dispute?
Calling as a prosecutor, you lead a team?
Yes, I do.
Mm-hmm. So, what are the demonstrable attributes of leadership which you have and you are bringing on board if you are successful?
Thank you, Commissioner. I would describe myself as a team player, number one, which is a very key attribute when you have a team of people that you are leading. First of all, as a leader, you should be able to accommodate difference in opinion from members of your team. Understand where each of those members is coming from, and then find a common ground of how you can work as a team. That is one of the attributes. The second one, I am not one person who is quick to passing judgment about people and their inadequacies. Before I make a decision about any of my team members, I have to get to the root of the matter and understand what would make one not do that which is expected of them as and when it's expected to be done. So that is another strength that I come with. The third strength as a leader that I would bring to the table is this: I lead an open door policy. Open door policy in the sense that if, as a team leader, any of my members feels they have a concern that they need to raise, I am not that person who says book appointments. You simply walk into my office, tell me what it is, and then I deal with that situation.
Thank you, CJ.
Thank you, Commissioner.
Thank you, Honorable CJ. Mr. Muteti,
Yes, Commissioner.
please tell us some of the ways, if you're successful, you will put in place to ensure that wellness is taken care of for yourself and the team that you'll be leading.
Wellness. Thank you. Commissioner, one of the reform initiatives that I think one could adopt in a station is having what I would call champions in respect of wellness. Persons who can act as mentors to others, persons who can deal with issues of counseling if they're in a position to do so, or you as a team leader inviting counselors to speak to your staff on matters wellness. Number two, develop a work schedule that also brings about work-life balance. Because again, that is a big challenge in public service, where people work all the time of their life, they have no time for themselves. That causes certain complications. So for purposes of wellness, that would be something that I would encourage, that people manage time effectively and allocate themselves also time to be able to remain fit. The other thing I would encourage is the utilization of the facilities that the institution has availed. For example, a wellness check for everybody in my team. If you have a policy that covers that, why is it not being utilized? And I believe largely because the staff are either not aware or they are not even sensitized on the need to do so. That's something that I would prioritize.
Good. I like that you've talked about work-life balance, and I hope you will not find yourself in a situation where you have to carry work home if you're successful again. But maybe you could tell us if you found yourself in a situation where you have conflicting deadlines, you have a lot of a heavy workload that you have to complete. How would you go about it?
Well, I think the first measure I would take is, first of all, creating time outside official working hours. Say, for instance, if you are expected to start court at 8 or 9, the hours before, you can utilize an hour or two. Later in the afternoon, once you are done with your court work, again, you could spare yet another hour or two to be able to catch up with whatever is pressing. Why do I say so? If you took, for example, 2 hours a day, 14 days, you would realize that translates into a whole day and to you as an officer. So it is just a question of being innovative in the approach that you take, ensuring that you don't keep matters pending when you can actually dispose of them, basically avoiding unnecessary adjournments. That's something that I would also embrace.
Okay.
Yes.
Delegation, is delegation part of some of the ways?
Delegation for non-judicial function that I would be performing if I find myself in a station where I'm the head, that I would do. But if it is the duty of the judge now to make decisions, that obviously I cannot delegate.
Okay, thank you. My final question to you is regarding a pile of documents that we received. I am sure you've come across this document. It's addressed to the Honorable Chief Justice, and it's been doing rounds on social media. So maybe just briefly tell us what you have to say about the documents. They were presented by Nelson Harvey, and in the letter he challenges your suitability for consideration in this role, where he says there was a gross violation of Bill of Rights in the matter where you recommended for arrest and prosecution of Professor Tom Ojienda in December 2018, recommendation for arrest and prosecution of Honorable Edgar Kagoni in September 2019, and then recommendation for arrest and prosecution of Honorable Lady Justice Philomena Mwilu in August 2018. And then another issue that was brought out was the area of alcoholism. Maybe just briefly, if you could talk about it.
Thank you, Commissioner. I am aware of that complaint, and I have the following to say. Number one, following a letter that I received from the Commission, I did prepare a response and I filed it with the Commission. Secondly, looking at that complaint, one can only characterize it in the following terms: malice, sheer malice. Why do I say so? In respect of the 3 cases that Nelson Avi alleges that I recommended, you will comb through that document and you will not find a single advice from me on any of them, advising either the police proceed and arrest, or even initiate prosecutions. Why do I say so? If you look at the 3 cases, Mr. Avi filed constitutional references in all, and I appeared with him in all those matters. Specifically, talking about the DCJ matter, I came into this matter the 2nd day after DCJ had been arrested and arraigned in court, released, and told to appear the following morning. I was involved in the matter the following morning simply to appear at the plea taking. And I would invite this commission, if you look at the file that was before Honorable Mugambi, Chief Magistrate, then now Judge, I made submissions to this effect, that I was under instructions to communicate to the court that the prosecution of the DCJ had absolutely nothing with interference with judicial independence. That was the submission that I was detailed to go and make, so that from the position I sat, I was acting under delegated authority, and I had given specific instructions on what to do. When he says I violated the DCJ's rights, I completely do not understand in what sense. Simply by appearing in court? Simply by assisting the lead counsel who was in the matter? How does that amount to violation? I would have loved to see any particularization of those particular violations, because he has not provided any, and possibly he could not, because if you read through the pleadings which he has supplied to the commission, throughout all the affidavits that they swore, filed in court, at no time did the name Muteti come up. I was not mentioned. But something important needs to be said again about that decision, because Mr. Avi decided to circulate this basically to besmirch my good character. If you look at the decision rendered by the 5 judges, you will find some very interesting pronouncement, and I captured it in my response. The judges in that matter did not actually even fault the DPP. That matter suffered the fate it suffered on account of illegally obtained evidence. Does Muteti collect evidence? No. Does the DPP collect evidence? No. And the judges went further and expressly stated that it was actually the investigative agency that went outside the orders that they had been given to by court. So my simple answer on the DCJ matter is that I never recommended arrest, I never recommended prosecution, but I appeared as counsel, as duty called upon me to do. In respect of Mr. Ojenda was arrested. Again, I was not involved in the decision for him to be arrested at all. But Mr. Avi omits to mention one thing, that when I got involved in the matter on a Saturday, if I recall very well, I went to DCI personally, and Senior Counsel Tom Kopere, who was appearing for Tom Ojenda, met me at DCI, and he told me, Mr. Muteti, Professor Tom Ojenda is a senior counsel. Why are these people keeping him in custody? I told him, actually, the reason why I'm here is because I do not want a situation where he spends an extra day in custody. And he was released that same day. So I actually did instruct the police to release him on bail. How did I violate his rights? None at all. The last matter, Mr. Kagoni. Mr. Kagoni was arrested in Mombasa when Muteti was in Nairobi by the police. My first interaction with that matter was at the plea stage at the court down in JKIA, led by Mr. Okello, the late, who was the lead prosecutor in the matter. We appeared, took plea. Mr. Kagoni was admitted to bail. Again, proceedings never even took off. I never prosecuted him. I never made the decision to prosecute him. I do not understand where really Mr. Avi is coming from. And the decision by Judge Nyakundi in that matter, again, does not fault me. And so is the decision in the Ojenda matter. This is why I said These are purely malicious accusations. Now, on the matter of Muteti being an alcoholic, and I do not understand how he arrived at that conclusion because he's not a medic to begin with. I used to take alcohol, but Mr. Avi, who happens to be my friend, I was surprised, doesn't know I stopped taking alcohol over a year ago. Common prudence would have dictated before you make such a monumental accusation as counsel. One would ask, even the friends that I sit with every day and colleagues at work, is this guy still involved in this? None at all. I do not drink, for the record. 1 year down the line. And even when I used to drink, I was never adjudged an alcoholic. I continued discharging my duty. And then, the holier than thou attitude that you find in the tenor and language in that letter surprises me. Mr. Avi himself takes alcohol. It's a matter of public record. So what I would urge this commission to do is this. In light of the provisions of Article 236 of the Constitution, which protects public officers from discrimination on account of performance of their duty, kindly protect me. Otherwise, you will never recruit a prosecutor in this country. Prosecutors do not serve cake and hell. They make decisions that cause pain, sometimes out of exigencies of work. And where one is not found at fault, please, this is the institution that should say no. Do not vilify public officers for simply performing their function. I have, Honorable CJ, been rated as the best public prosecutor of the year twice by the Nairobi Law Society. 2021, 2023. Mr. Avi is a member of that branch. He never raised any issues about this. So I believe from whatever may have motivated him to do all this, I can only leave him to God.
Thank you, Mr. Muteti. That was quite engaging.